Welcome to Call Frost First, Illinois Injury Law.
Welcome back to Call Frost First, Illinois Injury Law with KevinJFrost. Kevin is the managing partner of Clark Frost Zucchi and a trial attorney representing injured individuals and families throughout Northern Illinois. He has secured multi-million-dollar settlements and verdicts in cases involving trucking accidents, wrongful death, serious workplace injuries, and medical negligence. I'm Chelsey, and today we're talking about what happens during a personal injury lawsuit in Illinois. Welcome back, Kevin.
Thank you. Nice to see you.
Once a lawsuit is filed in an Illinois injury case, what does that actually set in motion?
Well, it sets in motion first putting the defendant or defendants on notice that there's a lawsuit filed against them. After that, you try to be contacted and have contact with a defense attorney, and even sometimes before you go to court, because it can be a couple months before your first court date. Sometimes you begin working on the exchange of information right away, and then eventually you would go through the process of utilizing written discovery, which is interrogatories, questions to the other side, and they would send them to you as well. And then normally what's called a request to produce. So that hopefully the beginning of the exchanging of documents that either I'm looking for on behalf of my client or they're looking for to obtain more information from my client. So those are kind of the first steps after filing a case.
What role do the initial filings play in shaping the direction of a case?
Yes. So the initial filing is the complaint, where you make allegations involving both the duty owed to the defendant, how they breached that duty, the negligent act or conduct that took place that we're alleging against the defendant, and then what the damages are to my client. So it kind of sets the roadmap, and you want to be specific on that moving forward. They obviously can be amended if facts change down the road, but you should have a pretty good idea of what you're looking to accomplish.
A large part of a lawsuit involves exchanging information between both sides. You touched on this a little bit. How does that process typically work in injury cases?
It's so important, right? So we talked about the written questions that are exchanged, the documents that are exchanged. Those are very important because you gather information, and sometimes maybe you don't get the documents that you asked for, so you have to maybe engage the court. And then after that, you move on to what's called oral discovery, and that's like the deposition process, right? And so that gives you a chance to depose witnesses, to depose the adverse party, to depose physicians, and likewise it gives the defense that same opportunity.
At what point do expert witnesses become involved, and how do they influence a case?
Expert witnesses can get involved either because there's some major discrepancy in how something took place, right? So the liability is in question. We're claiming it happened, X, Y, Z, and they're saying no, that's not what happened, or there's just a really difference of opinion as to who's at fault. That's a time when you engage an expert. For instance, you may have an accident reconstructionist come in and look at a particular intersection, the cars involved to determine the speed, a number of factors. Are there skid marks on the road? Are there something called yaw marks that are looked at? What was the point of impact? What was the point of rest? So you use an expert witness on a matter like that. They can be used on a medical question, right? So you have a case and one doctor says that yes, the motor vehicle collision caused the injury to plaintiff, and the defense sometimes hires their own independent person to look at it, or one they've retained, and says, oh, that's not how it happens. This person had this problem 15 years ago. So sometimes then, you may have to use an expert witness outside of your treating doctor to prove or disprove a theory that hopefully is going to benefit you as a plaintiff.
As a case moves forward, where do most disputes or pressure points tend to develop?
Earlier, I talked about depositions. I think depositions, so many cases are won and lost in depositions. You really get a chance to see the manner, the personality. Is this a likable witness, or are they unlikable? Are they telling the truth or not? Right. A lot of times you can tell, especially in a live deposition. Is the person being truthful or candid or not? Right. So that definitely is a really large role. Pressure points in a case can involve around depositions, disagreements that take place at depositions, or disagreements in testimony. That's definitely one spot. They also can involve, for instance, one side not producing documents. You've asked for documents, you asked for information, and you're kind of getting stonewalled on that. So that's another place where it can happen. They also can involve medical expert testimony. Right? There can just be a difference of opinion of what one doctor said. You can have two lawyers in the same room and spin it a different way. So and sometimes these points of contention, especially involving like document production or getting information, you have to bring one side. If you can't resolve it, you have to bring it to the court. Right? You have to file a motion and go in front of the judge and explain what you're asking for, and have a ruling made on whether it's relevant, whether or not he or she orders one side to produce the other side. So that definitely happens and is a major point of contention amongst parties.
Great segue into my next question. How do motions, that you just mentioned motions, how do they factor into the progression of a lawsuit?
So you go to a motion call as you report it in the status of a case, and either side can bring or file a written motion to get to an issue, right? And it normally involves a time when the lawyers are not in agreement, they're not getting along, and someone is refusing to do X, Y, or Z, right? So you file a motion to compel, saying I'm compelling the other side to answer these questions, right? Or I've asked for these specific documents and I don't have them, and they say they're not relevant, and I think they're relevant. So you'd file a motion to compel in front of the court and have the court make a ruling then in any particular issue that will affect the advancement of the case.
Can you share an example of how a case changed once it entered the litigation phase?
Most common way is through a deposition, right? There's a number of cases where you have independent eyewitnesses. So I had a construction case where there were 3 or 4 people there the day before and talking about a particular issue with whether or not a backup alarm was going off. And so you may think, or the other side may think that witness Jim Smith is going to say there was no backup alarm, and then during the course of the deposition he says, oh no, I remember being there, and in fact I remember telling my supervisor that same day that it was not working. So now you can have a major change in a fact on the case when the defense maybe has been purporting that like it worked just fine, and now you find out that really that's not the case, and you depose then the other 3 witnesses that were there, and the story remains the same. So you know that those are the facts, right? So the facts are as depicted and remembered by some witnesses. So it really can make a big difference under those circumstances.
If a case does move all the way to trial, what should somebody expect from that process?
So if it's going to go to trial, obviously that means it's been through the litigation, it's been in court for a while. You're going to get assigned a trial date that's some time off, and you're going to work backward from there to get there. The most important thing for a client is to be patient, right? These things take time. There may be sometimes you think you have a trial date on a certain date, and it gets bumped because there's another trial, or another trial lasted longer. So it's so important to be patient, right? I think once a trial starts, I think clients need to know that you may be there for a week, you may be there for 2 weeks. And when you're sitting there, everyone is looking at you, right? I mean, you're constantly being judged. It's important not to have any outbursts or show signs of frustration in court, because I think it's so important. I think, especially these days, for a jury to like the plaintiff. If you have a likable plaintiff, it goes so much further than a case where maybe they don't like the plaintiff, or there's something that maybe they don't like, and then they're just sometimes looking picking at reasons why not to award something to a plaintiff. So, and I mean, and we know this, and we obviously talk to our clients. I mean, we only want to represent people that are telling us the truth, and that are being consistent with their testimony. So these are all things that then, before the trial, then it's more preparation. It would take more time for our clients to come in and for us to review documents and review specific questions in advance. But it's a process, and hopefully, it pays off in the end.
Well, that wraps another great episode. Thank you so much, Kevin.
Thank you.
If you're involved in a personal injury case in Northern Illinois and have questions about the legal process, you can contact Clark Frost Zucchi for a free consultation at clarkfrost.com. Thank you for listening to Call Frost First, Illinois Injury Law. If this episode was helpful, subscribe, leave a review, and share it with someone who may find it beneficial.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.